one is a 3-day notice to quit. A 3-day notice to quit is exactly what it says it is. You don't get a chance to cure the conduct. 3-day notice to pay rent or quit, you got 3 days to pay. There is some behavior that's so egregious that you give up the right to remain in possession of the premises. This is a 3-day notice to quit. We're articulating nuisance conduct. Where we have significant and severe nuisance conduct, 3-day notice to quit. There is no right to cure the violation. How are you going to know whether behavior is sufficiently egregious that it renders the tenancy terminated on 3 days notice to quit versus a 3-day notice to cure or quit for conduct? It's all one of degrees, right? I, having done this for about 20 years now, will say to you what happens. And what I do as my expertise is, you show me what the situation is and I will have a dialogue with you. I may give them 10 days, 14 days to cure or quit for violation of the pet agreement, because you know why? It takes a little bit of time to relocate that pet. If I do it in 3 days, on the 4th day I can file the eviction action. I don't want to file the eviction action. I want them to get what? Rid of the pet. You got to be careful. You can't say we have a no pet provision, because that's not a pet. An owner in possession of a unit, is that owner a tenant? No. So that owner, if he remains in possession of the unit after the unit is no longer that owner's, because the grant deed or a deed has been filed, that owner would be subject to a 3-day notice to quit. And therefore, if you've got a former owner in a property, they're not entitled to tenants' rights because they are not a tenant. When a son has permission to be at a premises, what can you do when you're no longer interested in the son remaining in the premises? You can rescind permission. I give you this example because oftentimes people will come to me, they have a crisis, and they're worried about whether we have to follow the rules of the rent ordinance, and I have to first figure out what is the status of that individual. Is where I'm telling you, cure your conduct, and if you don't, you can be evicted. Now the tenant has one other choice. It's called cure or quit. What else could the tenant decide to do as opposed to cure their conduct? They can leave. They can leave during the 15-day notice period. If a tenant has lived there less than a year, the termination of a tenancy can be on what? 30 days notice. If the tenancy is more than a year, what must you give them? 60 days notice. I don't make this up. It's statutory driven by California law. So the problem with certified letter, even though you have the right to serve by certified letter, oftentimes it takes 2 weeks before they actually pick it up at the post office. So they've lost 2 weeks of time to actually find another place to go. So my advice is typically, I don't like to serve things by certified mail. I like to usually personally serve, or if no one's home at the address, post a copy on the front door of the unit and also mail it. Normally when you post and mail, they get it. Email right now is not a agreed upon method by which you can serve these notices. Doesn't matter that you sent it, it matters that you comply with the law, and the law requires posting and mailing, substituted service, or personal service. And what this really is about is due process. Due process of law requires someone to be informed of what may be proceeding. If they don't know about it, they haven't had their due process rights preserved. So I use posting and mailing as an effective device to ensure timely payment of rent throughout the community. 95% of the time, the tenant's going to get it and it's not going to be a problem and they're going to pay. But when you end up in an eviction action and you get a clever tenant attorney and they say, how was this served? I only got it under the door. The tenant attorney will write me a letter, I'm sorry, dismissed the case, this wasn't served correctly, my client was not served properly.
My name's Marie, and I'm from San Leandro, and I came here because I wanted to be more informed of the eviction rules pertaining to Oakland, and it was so informative. I was so enlightened, and I feel empowered by this brief workshop, and I'm going to use the information that I've gained today just by one-on-one asking him, and I'm sure when everyone else was able to gain knowledge from that too, from the question and answer session. I would call him definitely if I ever had an issue with my tenants, especially particularly an eviction. I would definitely call.